Hi there, this is Jonathan Ginsberg, and this is part 2 of my discussion about reaffirmation agreements in Chapter 7. In part 1, I told you about the difference between secured and unsecured debt and why secured creditors are secure, that they have two types of interest in your property, or two types of liability against you. One is you promise to pay, that's the promissory note. The second, they have a security interest where they've actually linked their claim on property to your particular property. So they have an interest in your house, your car, whatever it may be. And when you file bankruptcy, the promissory note part is discharged with the discharge of your bankruptcy, but the property interest stays. That's why when you file bankruptcy, you don't get to keep your car even though it's only half paid for. The property interest remains, and the lender can foreclose against it or recover that. So let's talk about what happens when you're in bankruptcy. Again, when you file bankruptcy, something called the automatic stay goes into effect, and the automatic stay prevents creditors from taking action against you. And specifically, it stops secured creditors from pursuing their rights. They can't foreclose, they can't repossess, they can't do anything to pursue their rights against you. And in fact, if you do nothing, the promissory note will simply disappear, meaning that your personal obligation to pay disappears with the discharge in your Chapter 7. But what happens if you have a car or a house or something that you want to keep? And again, you've got to pay for it. Obviously, you can't keep it, and there's no free lunches. You're not going to get it and get it for nothing. So what happens? Well, the bankruptcy, Congress in writing the bankruptcy code came up with this procedure called reaffirmation, which is essentially where you renew your promise to pay. You renew the promissory note. The underlying security agreement remains in place regardless of what you do with reaffirmation, but now you're agreeing to promise to pay. And of course, from the creditor's perspective, now they have two claims against you, two ways to tie you down. One is the promissory note, the other is the security agreement, so they're going to be more secure. The second thing to be aware of is that in almost every promissory note and security agreement, a bankruptcy is considered a default event. So if you file bankruptcy, technically you're going into default, which means that, again, if you don't do anything to give that creditor some security, security meaning some sense they're going to get paid, after the bankruptcy is over, they would then have the right to, the automatic stay is over, they could then repossess, foreclose, do whatever they wanted to do. They couldn't come after you for any deficiency balance, but they could take your property back. So reaffirmation is a way for you to basically have, to be secure in your own sense that you're not going to wake up one day and see your car gone. You're going to go ahead and re-establish your personal liability on that note. And so when we file reaffirmation agreements, typically they're prepared by the lender. They send it to me. It's usually about a 10-page document, and we've got to show a number of things. And again, when you go into a bankruptcy, there's a lot of strings that get attached, and for reaffirmation it's no different. And here are the strings that you need to be worried about. One is that you don't have an automatic right to do so. The creditor has the right to say, we don't want to reaffirm with you. And the reason a creditor might do that is they're going to want to see that you're current. So string 1 is you've got to be current with your note, or pretty current with it, to be able to reaffirm. And pretty current means that you've got to be able to bring it current before the case is over. So if you want to reaffirm and you're behind 5 or 6 months in your car note, you're not going to be able to reaffirm in 99% of the cases. If you're current, the lender is going to be more likely to want to say, yes, I think this person has the capacity to pay, and we're going to let them reaffirm. The second string is, so the creditor has to agree, that's string 1. The second string is that the secured lender has got to cooperate in the process. And again, what I mean by that is that they have to provide us the reaffirmation documentation. Every once in a while, I'll see a secured lender ask me to provide the documentation, but they typically have their own forms. They send it to me, we fill it out. Again, it's about 10 pages. It has all this information about your budget and so forth. We send it back, and they have to file it. And I will tell you that there's a certain percentage of cases where, even though we do everything on time, the lender just doesn't file it on time. It doesn't get filed, and there's new reaffirmation. So the lender has to cooperate and participate by actually getting the reaffirmation filed. filed. And if they don't do it, there's pretty much nothing we can do to force them to do so. I've had a number of cases where we did everything right, the lender didn't do it, and then once the case is closed, there's really nothing you can do to get the reaffirmation filed. You can file a motion to reopen. You'll see on the internet people talk about filing a motion to reopen cases, but I will tell you, in my experience, at least here in the Northern District of Georgia, judges are very reluctant to reopen a case so somebody can file a reaffirmation agreement. So don't assume that will happen, because it probably won't. So again, the second string here is the lender has got to cooperate. The third thing is that the trustee has to cooperate. Remember, when you file bankruptcy, something called your bankruptcy estate is created. That's really everything you own. So if you go into a bankruptcy and you've got a car, a house or something, if there's any equity over your exemption limits, then the trustee will take an interest in it. And remember, exemptions are what you can shelter or carve out. So, for example, if you've got a vehicle worth $3,000 or $10,000 under the bankruptcy law, the exemption statute now in force in Georgia, you can shelter $3,500 of that, but $6,500 is non-exempt, and the trustee would take an interest in it. And you can certainly buy the trustee out of his interest and things like that, but for the most part, the trustee is going to say, I want that vehicle, I'm going to go ahead and sell it for the benefit of unsecured creditors. Same thing happens in reaffirmation. If there's a lot of equity after taking into account your exemption and the creditor's lien, the remaining balance on the note, then the trustee might take an interest in it, and you would not be able to reaffirm. The only way you'd be able to reaffirm would be, not only would you have to pay the lender, but you'd have to buy the trustee out of his interest. It's pretty rare that we see a lot of equity, but it does happen sometimes. So just be aware that if you have a lot of equity, there could be a problem with the trustee. Okay, the next issue, the next thing we have to worry about is whether or not you can afford to make payments on your secured debt. And this kind of gets to the heart of reaffirmation. And what I mean by that is that in the old days, we would simply reaffirm a lien, a claim, and file a 1 or 2 page document, and it would be reaffirmed and nobody worried too much about it. Well, when Congress changed the law in 2005, what they did was they made reaffirmation a much more complex process. We have to now show that your budget allows for it. So when I originally do a budget, I've got to show that there's enough money left over on your budget to allow you to reaffirm. So if we look at your budget and you've got a family of 4 and we can only schedule $100 for food, but you want to reaffirm a $400 car payment, that's probably not going to work. And even more so, what Congress did was that with reaffirmations, that the judge has to agree to it, and if, again, there's not enough money in your budget, the judge will not agree to it. And also the attorney, I have to sign off on it, that I've looked at this and I think that my client has the wherewithal to fund this reaffirmation. And in theory, there's liability. So if I sign off on a reaffirmation agreement and it turns out you really didn't have the wherewithal to make the payments, I could face some liability. So I'm very reluctant to sign a reaffirmation agreement unless I see that my client is gainfully employed and there's enough money to cover the cost of his monthly payments. And of course, the judge will not sign off on it if you don't have enough money on its face. So there have been a couple of cases even where I won't sign off on it because I don't think my client has the wherewithal to make the payments, and I'm not willing to take the risk. We'll go in front of the judge. The client will argue to the judge, yes, I do have, I can rely on my brother-in-law to make to loan me money every month. And sometimes the judge will buy it, sometimes the judge will not. But you've got to be able to show, at least on paper, that you have enough money to make things work. And again, as your attorney, I've got to be pretty comfortable that you're willing to do that, you're able to do that as well, because again, I don't want to face any liability, and I want to make sure that I'm properly advising you. I'm not doing you any favors if I sign off on a reaffirmation that I don't think you can afford, and then 6, 8, 9 months from now, you get sued by a lender for a deficiency balance when your car gets repossessed. So we all want to avoid that, but again, the Congress has raised the stakes a little bit. They've put the judge involved. They put the judge involved in the process. They've put attorneys involved in the process, and that's kind of what happens. Now, if you cannot reaffirm for whatever reason, for example, if you're unemployed, you can, in some cases, do what is called a stay and pay or a keep and pay, where you continue to make payments, but there's no documentation, there's no reaffirmation agreement signed. You're simply making the payments. And many lenders are more interested in the money than anything else, and they'll let you do that. What that means, of course, is that if you stop paying down the road, they can get their property back, but they cannot sue you personally. And of course, there's an uncertainty there because what do we know for certain that a lender will not just grab your property? You have nothing to hold them to say that they won't, but that is a way to keep your property and still pay for it, even if you don't qualify for a reaffirmation. So that's kind of big picture about how reaffirmation works in bankruptcy. Next segment, I'm going to talk about the pros and cons and what happens if you reaffirm, what happens if you don't, and that sort of thing, and some of the issues that some of my blog readers have found themselves faced with. So for now, this is Jonathan Ginsberg, and we'll talk to you soon.